Hazeltine, I may be pronouncing that wrong, is a fairly recent warrant. I would, if we're comfortable addressing that on the record.
Yep, Mr. Hazeltine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Hazeltine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction. Feel comfortable with this court moving forward. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Hazeltine, is the person here. And I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Hazeltine, then you're a spectator and you're welcome to stay. If you are Ty Hazeltine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Hazeltine?
Does the caption of this case not say Ty Warren Hazeltine in all capital letters?
Your Honor, I can speak with Mr. Hazeltine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yep. If you're Ty Hazeltine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Hazeltine. So I'm going to strike Ty Hazeltine's hearing and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're gonna.
All right, buckle up, because today we're stepping into not one, but two sovereign citizen courtroom showdowns, and both of them spiral exactly the way you think they will. We got defendants who insist they're living men, who refuse to acknowledge their own names, who demand injured parties for traffic tickets, and who genuinely believe that if they just say enough magical legal phrases, the entire judicial system will collapse. And here's the twist. Judges in these cases? Calm. Surgical. The first case, a man misses court, shows up on Zoom, refuses to confirm his identity, and somehow thinks that's going to help him quash a warrant. Spoiler alert, it does not. In fact, it goes RL, we head to Michigan, where another defendant insists he doesn't plead to anybody but God. Sounds bold, right? Except he's the one who requested the hearing. And when a magistrate lays out his three simple options, what does he do? He argues jurisdiction over a...
Calling case number 24, RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of...
Here. This is classic sovereign citizen script reading. You'll notice the rhythm. Living E of joinder, lack of jurisdiction. These are phrases lifted from online templates that promise immunity from court authority. But here's the problem: doesn't automatically trigger legal determined jurisdiction based on location, time, and subject matter. If you're physically present in the county when you violation, Jurisdiction is almost automatic. It's procedural. Not what makes this moment especially important is that the judge isn't debating ideology. She's focusing on one simple issue: identity. Are you the defendant or not? Because if you refuse to confirm who you are, you're not outsmarting the system. You're just removing yourself from
Hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, air near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options, and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by
No,
law.
I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very
So I
well.
have a question.
Officer Moran,
this could have gone differently. Courts are often incredibly lenient on missed appearances, especially for lower-level matters. A simple acknowledgement, yes, that's me, I apologize, could have resulted in a new date and 0D by refusing to identify himself. He essentially told the court, that's not me. So the judge did exactly what procedure requires. She treated him as a spectator and left the warrant. Is where sovereign citizen tactics backfire hard. The system runs on procedural compliance. When you refuse to engage with basic identity confirmation, the court can't even reach the merits.
I do.
thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that
And
time.
that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you
Go again, the living man distinction. This argument is rooted in the idea that there's a separation between a person's physical self and a corporate entity represented by their name in capital letters. It sounds complex, almost intellectual, but legally, it holds zero do not recognize a split identity between a living man and a corporate fiction. Your driver's license, your registration, your physical presence, that's you. The same you who requested this informal hat's what makes this moment so interesting. He voluntarily asked for this hearing. The court didn't drag him in. He invoked the process, And now he's resisting the very structure he like ordering food at a restaurant and then refusing to acknowledge you're the one who ordered it.
You a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in terms of who's present on behalf of the city?
This is where misunderstanding procedure really becomes expensive. In civil infraction hearings like this, a plea isn't a moral submission. It's a procedural selection. Admit responsibility, admit with explanation, or deny responsibility and proceed to TS, not about pledging allegiance. It's about choosing which C the hearing F. He says, I don't plead to anybody but God. He's framing this as a spiritual standoff. But the magistrate isn't debating theology. He's following statutory requirements. If you request an informal hearing, the rules require 8P the magistrate's tone. Calm, clear, no emotion. He repeats the options. He explains the...
Understand your question. Are you asking where it is on a map or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written under the vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward. As far as the injured party, no one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case under the Motor Vehicle Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it is.
Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the Chief Judge of the District, and at that time, the City of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of one.
Jurisdiction arguments are the sovereign citizen cornerstone. But here's the reality. Jurisdiction in traffic matters is straightforward. The court has authority because the alleged violation occurred within its geographic boundaries. Under state